Good afternoon, everybody. Welcome. I'm David Erickson, Dean of Law School. It's my great pleasure and privilege to welcome you to the 9th annual Erickson Distinguished Legal History Lecture. So once again, we have a wonderful speaker and a fascinating subject. And you may ask why we have an annual legal history lecture. The simple answer would be that those who forget history are condemned to run for President of the United States. That's been my impression from watching the debates. But if you want to get the sounding theory and just go directly to the elimination, then this is the lecture to attend. And we're really delighted to have Bob here from Stanford for our Erickson lecture. Now, whether the study of history can help us avoid the mistakes of the future at the debate of a different time, that's not really our goal with the Erickson lecture. Instead, the goal of the lecture really are about acquiring knowledge that will help us better understand ourselves, our society, and the role of law in it. We can't all make history, but all of us can learn from it. And again, as Oscar Wilde pointed out, any fool can make history, but it takes a genius to write it. So I'm going to turn the podium over to one of our own legal history geniuses, Suzanne Blumenthal. But before I do, let me briefly thank two people who have made this lecture possible. Now, you might guess from the fact that this is the Erickson lecture, I will be thanking some Ericksons, in particular Ron and Chris Erickson. Ron, who's chairman and CEO of Holiday Companies and the vice chairman of Gander Mountain, who could not join us today. But we're delighted to welcome Chris Erickson, who is here, and who is a partner at Greenwood Capital Partners. He's a recent past chair of the Law School's Board of Advisors, member of its campaign cabinet, and has long been an invaluable advisor and supporter of the law school. Chris, we really appreciate your support and Ron's, and also their son David, a recent graduate of the law school. So we thought it was fitting today to have one distinguished historian introduce another. And so we've asked Professor Susanna Blumenthal, who divides her time between the law school and the history department, and who just has her own book published just this fall. Pardon?
Just this month.
Just this month? Well, okay, keep counting. Just this month. I suspect Susanna might be. We've asked her to do the honors and introduce our lecturer. Susanna?
Good afternoon. I'm Susanna Blumenthal. I co-direct the program in law and history here at the University of Minnesota, along with Bob right back there. I'd like to begin by joining David Whitman in expressing our deep appreciation to Chris and Ron Erickson for their generous support of the law school in the program in legal history. This lecture, which has made it possible now to bring to the university campus some of the most distinguished scholars working in the field of legal history, is a product of their generosity. Thank you, Chris. It's really wonderful to have you today. Our intellectual, professional, and service mission depends upon the generosity and vision of individuals like the Ericksons. In addition, events like this depend upon the efforts of a cadre of members of the law school staff, whose talents, professionalism, and commitment to excellence in every detail have quite literally made Professor Gordon's visit, this lecture, and the reception to follow happen. This year, as in years past, we are deeply appreciative of their work. Please join me in recognizing and thanking Amanda Gonzalez, Garrett Howe, Cynthia Huff, Linda Lokenskard, Laura Walton, and especially Angela Tanner. And now it is both my privilege and my great pleasure to introduce Professor Robert W. Gordon. Professor Gordon received his A.B. from Harvard University and his J.D. from Harvard Law School. He is a professor of law at Stanford Law School and Chancellor Kent Professor Emeritus at Yale Law School. While he has spent the bulk of his career on the faculties of the law schools at Harvard and Yale, he has also served on the faculties at the University of Wisconsin-Madison and the State University of New York at Buffalo. In addition, he's also been a visiting professor at Harvard University, Oxford University, the University of Toronto, and the European University Institute. He teaches courses in legal history, social movements, the American legal profession, as well as contracts and evidence. His Fellowships and honors that have been conferred on Professor Gordon are too numerous to list, and the same can be said of the advisory and leadership roles he has assumed within and beyond the realm of the academy and the legal profession. For over 40 years, Professor Gordon has been publishing singularly important work concerning the history, theory, and practice of law. And his contributions to the legal academy and the profession transcend what appears in print. As a teacher and mentor, he is famously generous and has powerfully influenced and inspired generations of lawyers and legal scholars. I count myself extremely lucky to be able to personally attest to this, though it makes it all the harder to speak succinctly, as I must in this short introduction, in which I will focus on his contributions to the field of legal history. Like many, I first came to know Professor Gordon by reading his work, and more particularly his seminal 1984 Stanford Law Review article, Critical Legal Histories. It stands as a truly transformative piece of scholarship, a work that challenged reigning paradigms, set the agenda for legal historians of my generation, and has since become an unquestioned classic in the field of legal history. In fact, it is fair to say that many of his key insights have become working assumptions in the field. Critical Legal Histories has taught us to be skeptical of the functionalist narratives of legal change, determinist storylines that treated law as a secondary body of phenomenon called into existence by the primary social world and its needs. This, Professor Gordon contended, was not generally true of law's role in the history of human societies. To the contrary, he insisted on the fundamentally constitutive character of legal relations and social life, emphasizing the power and pervasiveness of legal concepts in our everyday activities, and he further called attention to the cultural contingency and indeterminacy of law over time and space. Taking up the charge of critical legal histories, scholars over the past 25 years have produced a wide variety of detailed historical accounts, tracing the life of legal concepts as lived social realities and identities, and recovering forgotten perspectives, paths not taken, and alternative ways forward. These works not only bear the imprint of Professor Gordon's framing ideas, they also reflect the enormous amount of time and energy that he has devoted to the task of teaching and advising graduate and law students aiming to enter the academy as legal historians. By a significant margin, he has formally trained more JD PhDs in legal history than any other scholar, and he has informally worked with countless others, remaining at the vital center of a flourishing field he has done so much to foster. All the while, he has continued to illuminate the path forward with a dazzling array of influential books, articles, and essays, which mainly revolve around two career-long obsessions: the uses of history in legal argument and the history of law as a public profession. The list of works here is too far by any stretch of the imagination to even attempt to summarize here, though I will particularly take note of his forthcoming volume of essays entitled Painting the Past, Law and History, and History and Law, to be released this fall by Cambridge University Press, and another work soon to follow on the American legal profession, 1870 to 1900. To summarize, to read Professor Gordon is to be continually struck by his piercing intellect and the utterly unique combination of curiosity, erudition, rigor, enthusiasm, and wit. Happily, this is true of him in person, as well as in print, as you're about to see. I'm going to turn the floor now over to him with gratitude. He will speak to us today about morals, markets, and lawyers. Please help me.
Thank you very much, Susanna. That was very, very gratifying and also rather embarrassing. Anyway, very nice. I also want to thank the Erickson family for their generosity in endowing this series of lectures. I'm delighted to see that people think that history is something that should be taught and learned about in law schools. I'm obviously committed to the idea that it's a very important subject for lawyers to know something about, and it is gifts like these that make the spreading of this knowledge possible. I also want to thank the Whitman and I'm very grateful for this invitation, partly because it comes from an an institution where there's some very talented legal historians practicing. There's Susanna herself, and who's just come out with this wonderful book called Law in the Modern Mind, which I recommend to everybody here. Jill Hasday and Barbara Welke. So what's this all about? This is going to be, this is not a micro detailed lecture. This is kind of like a big picture lecture. And I want to talk today about an old and continuing controversy. I have a few PowerPoint slides of text. I'm not very good with PowerPoint. I'm just learning how to use it. So this will be pretty crude, but I think it will help follow along as I talk. My subject is an old and continuing controversy about the relationship between capitalist market systems on the one hand and their moral, social, and political underpinnings. The relatively unfamiliar ingredient that I want to stir into this old controversy is the role of law and lawyers in helping to counter what thinkers since Adam Smith have identified as certain pathologies to which commercial societies are prone. To many of you, I know, I think this thesis will seem to you rather counterintuitive. Many people are more used to thinking of lawyers as a cause of social pathologies than as a cure for them. But there's a respectable tradition that holds that they are a cure. Here's the outline of the controversy. We start with the premise that the successful functioning of a society whose dominant mechanism for allocating goods and services and satisfying individual needs is a capitalist market system. I'm going to call this commercial society. Essentially depends on an infrastructure of moral character traits and social and political institutions which are located outside markets and indeed not considered to be proper subjects of commercial exchange relationships. The most optimistic view of commercial society is that it is self-sustaining because the spread of commerce will itself serve as the civilizing influence that will produce the supporting orders and character traits that it's dependent on for its survival and growth. This is the doux commerce, or gentle commerce thesis associated with Montesquieu and the Scottish School of Political Economy, Adam Smith, the Miller, Ferguson, Keynes, Hume, and so forth. But there are less optimistic views, elegantly summarized by the economist Joseph Schumpeter. Schumpeter's paradox is the proposition that commercial societies tend over time to erode the very supporting orders on which they depend. This thesis, by the way, is as old as modern capitalism itself. There were contradictions in capitalism well before Marx and persisting after the demise of the Marxist tradition. And there are many recent restatements of the thesis. Fred Hirsch and Richard Titmus, for example, argued that commercialization undermines the social norms that sustain incentives to produce certain kinds of public goods. Daniel Bell argues that the opportunities opened up under an advanced capitalism for hedonistic consumption and careers outside traditional production generate countercultures that are corrosive to capitalist institutions and character traits. Robert Kuttner, Margaret Jane Radin, Michael Sandel, and Deborah Satz, among many others, argue that commodification progressively invades and degrades spheres of life in which some things and relations should not be pursued. What has any of this got to do with law? A lot, it turns out. The political economy of the Scottish school itself, Adam Smith's school, was developed as a branch of the science of jurisprudence. Smith's famous book, The Wealth of Nations, started off as a section in his law lectures, his lectures on jurisprudence, dealing with the police functions of government to produce public goods like sanitation, security, abundance, and above all, justice. The whole point of legal thought in this tradition was to come up with a reasoned account of the optimal set of public and private law rules and institutions, which they call justice and legislation, which is required for the sustenance of commercial societies. Just law and wise legislation are already central to the proper foundations of commercial societies. So the question becomes, if everybody is out there making money, and maximizing individual benefit, who is going to produce those public goods? In the early American Republic, it was a group of influential lawyers responding to contemporary concerns over the self-destructive pathologies of commercial societies, who proposed an ambitious set of intellectual, social, and political goals for their own profession as the solution. Lawyers, they argued, making and administering laws could serve as the mainstay of the rights of property, the restrainers of both of private predation and democratic excess, and even as the personal exemplars of the civic and personal virtues. They took this quite seriously. They wrote out biographical lives of lawyers to circulate to school children. So that they could read about these tremendously gifted and noble people. The lawyers' influence enabled them to put much of their program into effect. Yet, early on in the 19th century and repeatedly thereafter, the profession's subsequent experiences furnished ground for serious worries that law and lawyers might actually have in some ways worsened the very pathologies of commercial republics they had been claimed to be able to cure. Now, this is a continuing set of arguments. The arguments don't just made once and get resolved. They're reiterated many times over the last 2 centuries. So, following the lead of the late great economist Albert Hirschman, who elegantly summarized the first 2 phases of these arguments, the arguments in my talk proceed in 4 stages with a fifth tacked on at the end. The first, du commerce, arguments that the growth of commerce itself produces the social conditions that are the supporting conditions for commercial society, social harmony, liberty, just property distributions, appropriate moral dispositions, and character traits. Stage 2, counter-arguments that the expansion of commerce and attendant luxury, self-seeking, inequality, and so forth actually erode the supporting conditions of commercial society. Stage 3, arguments that law and lawyers can then palliate or help to repair many of the pathologies pointed to in the counter-arguments. Stage 4, counter-arguments that law and lawyers only serve to make most of these pathologies worse. Stage 5, there's a little postscript which says, yes, but is there a way out? Is there some hope? So, let me first apply a somewhat fuller, though very selective catalog of prevailing views on what the supporting orders are, the institutional, social, and cultural foundations that are required by commercial societies. Let's see if this works. It does. The first foundation is what Adam Smith called justice. The quote from him, the second duty of the sovereign after national defense is that of protecting as far as possible every member of society from the injustice or oppression of every other member of it. The role of justice is to define the elements of property and personal security, to secure their protection against crime or tort, and to enforce contracts, all by means of a reasonably efficient civil and criminal justice system administered by impartial and independent judges. And to this minimum, Smith and his successors added legislation, a more or less expansive conception of public goods, defense, public works, education, religious instruction, research, protection for substance to infant industries, control of monopolies, relief of the indigent for victims of business cycle, and so forth. Now, justice seems to require a core of impartial, independent judges, and with lawyers to bring cases and advise the judges. Good legislation requires not only a healthy competitive politics, but a directing class, a talented directing class of official and unofficial elites who are expert in what that generation called the science of legislation, as well as competent and honest in administration. It ultimately may require democratic legitimacy as well, but I will skip over that in the interest of time. Now, the second foundation is a background moral and social order, a set of norms and cultural practices which are thought to generate character traits and attitudes and behaviors which are conducive to the smooth functioning of the market system and the stability of its social supports. Among the most important of these, self-discipline, ability to postpone gratification, to save, to work hard, deference to the authority of moral socializing agents like parents, teachers, employers, and masters, respect for law, order, and property of others, responsibility for family and children, trust, honesty, and cooperation in business dealings. Now, obviously what's stressed in the catalog and in the institutional means that are proposed to socialize people into it may differ according to the politics of the speaker, but there's a convergence of opinion on the notion of the need to socialize people into restraints on immediate and individual self-interest. The market system does not work on simply everybody grabbing as much as he can. It works on enlightened and long-term self-interest. Families, churches, schools, and employers are obviously the most important producers of moral norms and individual practices, but law, as we shall see, claims an important role as well. But what are the effects of commercial development on those supporting orders? First theory is du commerce, gentle commerce. The du commerce thesis is that the expansion of commerce can, in and of itself, serve as the civilizing influence that produces the cultural conditions that are necessary for its survival and growth. So commerce promotes political and civil liberty. It expands the middling rank of men whose interest lies in the destruction of aristocratic and ecclesiastical privilege and the removal of feudal and mercantilist encumbrances to alienation of property and mobility of labor. This middling rank, or middle class as we now call it, has other virtues. Its independent distaste for servility becomes the chief guarantor of republican liberty. Its need for predictable property rights and exchange rule promotes the rule of law and political stability. Its desire for profitable trade deters it from financing rulers' appetites for destructive wars. Its hankering for mutually beneficial intercourse overcomes tribalism, xenophobia, and distrust of strangers and foreigners. So the merchant class inward exemplifies the sustaining character traits of rational calculation, saving and self-discipline, ambition for achievement, energy, curiosity, cooperation, prudence, and moderation. And it sends its offspring off to staff the socializing agencies, families, schools, academies of useful arts necessary to reproduce those traits. So commerce overthrows tyrants and rentier landlords, installs in their places beneficial laws, reduces dependence of some groups of men on others by making every man a merchant subject to the multiple connections of an impersonal market, civilizes and softens manners out of the desire to earn commercial goodwill, and such manners ultimately make and fertilize the arts and sciences of urban civilization and promote international cooperation through trade. And finally, the market is the tester and rewarder of character. It rewards talent, cooperative sociability, saving for investment and hard work with commercial success, and leaves the idle, improvident, and incompetent behind. Now, du commerce, this often is used, no relic of the 18th century. It has many enthusiastic promoters in our own day. George Gilder, endowment of capitalist entrepreneurs with the heroic virtues of the ancients. Michael Novak's defense of capitalism is the most practically effective means of putting into practice the Catholic ethic of social care. Jurgen McCloskey's multi-volume celebration of the bourgeois virtues arising from capitalism. And related, if rather different in emphasis, Benjamin Friedman's arguments that attitudes of tolerance for diversity and pluralism, welcoming of immigrants, economic fairness, and race and gender equality, mobility and opportunity, care for the environment, all flourish in periods of affluence, fueled by strong economic growth. Now, all of these accounts recognized that the crudest kind of narrowly self-interested motives, each individual is grabbing as much as he can regardless of others, can't by itself make markets work. What works is enlightened self-interest informed by experience. The spread of commerce leads to relations of interdependence and norms of reciprocity. Honest and reliable dealings invite cooperation and mutual trust. Swindlers and welshers earn bad reputations and are accordingly penalized. This argument goes much further than the classic sort of Mandevillean argument that private vice leads to public virtue, that the invisible hand produces outcomes not aimed at by any selfishly self-interested trader. It's an argument that markets need moral underpinnings, tempering crude selfishness and enlarging self-interest, and that providentially they tend to generate their own implicit moralities, the networks of norms that sustain their effective functioning. Now the Scots, like Smith and Hume, they conceded that commercial societies developed a kind of social personality that was radically deficient in the virtuous character of the ancient Republican citizen who sought honor in the service of the city rather than wealth for himself. But the Scots tended to think that this loss was more than compensated for by commercial societies' greater and more widely shared prosperity. Markets don't require heroic civic Republican citizens, but they do require appropriately socialized characters whose acts and dispositions are satisfying to their own impartial spectators, civilized and prudent people whose instincts are for cooperation and mutual sympathy, not simply scramblers for personal gain, but endowed with the bourgeois virtues, ultimately, they concluded, greatly preferable to aristocratic and military elites who prized violence in the vain search for power and honor. Few people ever subscribed to commerce thesis in such a in so unqualifiedly optimistic a form. The main anxiety of the promoters of commercial society was not about the loss of ancient virtues, but about the proposition and propagation of new vices, self-generated pathologies of commercial society. First, threats to the functioning of the legal framework of justice and wise legislation. For example, all of this all following examples come from Smith's Wealth Citations, Book 5. Merchants may engage in conspiracies to subvert competition or to extract monopolies, privileges, or immunities from the state. Commercial interests try to convert their economic and political power. This corrupts legislators and other state officers, but more fundamentally corrupts the whole of civic life, because such magnified economic power creates dominations and dependencies among citizens who should be independent. It short-circuits both democracy and wise legislation by turning policymaking into a series of corrupt deals between lobbyists and politicians. The expansion of commerce also brings about increasing wealth disparities, and with them envy, and hence pressure from below for leveling redistributions. Adam Smith himself warned that among the laboring classes, the increasing division of labor leads to stupidity, ignorance, incapacity for public life, to creation of a permanent proletariat, to oppression by the rich of the poor, to urbanization resulting in the lessening of social cohesion, of country life, to a popular culture given to enthusiasm, sedition, and action. Short-term calculation may lead to strategic behavior, opportunistic defections in the performance of contractual obligations, cunning simulations of honesty and reliability. Now, to guard against such tendency, commercial society requires a governing class of independent and incorruptible judges, wise legislators, and competent administrators, with the fortitude to resist special interest pressures and the authority to enforce their decisions. But where are such people going to come from? Unfortunately, they concluded, commercial societies do not always produce characters with the necessary knowledge and authority to staff the institutions of justice and legislation. The commercial life propels to its top ranks people with little appreciation of the institutional preconditions of their own practices, much less formal training or experience in the science of the legislator. People who tend to take the framework of justice and public good so much for granted that they don't realize how much they need it, who are quick to call the cops or go to court if their own rights are violated, but condemn similar actions against themselves as foolish and dangerous litigation or regulation. The restless search for profit turns people away from public regarding activity, devalues the non-commercial goods of honor, fame, and service. If such characters emerge in public life at all, it tends to be as an extension of their self-seeking in the market. They become rent-seeking politicians who degrade trust in government and its capacities. Oh, that's the worst-case scenario. Anyway, it's not clear that businessmen can achieve the authority to command sufficient deference to their administration of the legal framework. Adam Smith tells us that the dispenser of justice must be respected as a social superior. The magistrate must appear to be set above and apart. Stable property depends on stable authority, but the authority of commercial wealth is always unstable. Money getting isn't always impressive to the masses, though I'm experienced that it sometimes is. Commercial success seems frequently only arbitrarily or even negatively related to the traditional virtues. And of course, the possessor of wealth can always lose it or be outshone by somebody who has who has more. Those who celebrate winners must confront the possibility that someday they may be losers. Schumpeter, to quote from Schumpeter, the medieval lord's profession not only qualified him admirably for the defense of his own class interest, but also cast a halo around him and made of him a ruler of men. Of the industrialist and merchant, the opposite is true. There is surely no trace of mystic glamour around him, which is what counts in the ruling of men. The stock exchange is the poor substitute for the Holy Grail. This insight led to Schumpeter to his own version of Tocqueville's thesis that the emerging American bourgeoisie had ironically to rely on the leadership abilities and traditional authority of the old aristocracy of the Ancien regime as mainstays of the rights of commercial property. Threats to manners and morals of the private virtues which sustain commerce in the Republic. This tradition of social thought is very ambivalent about luxury. On the one hand, in Adam Smith's account, the love of luxury plays a key role in the downfall of feudalism, because nobles made concessions to their tenants, relieving them of feudal obligations in order to obtain the rents they need to finance their love of baubles and trinkets. But over time, consumption habits override saving habits. The taste for idleness drives out the taste for hard work. Speculation drives out prudent investment. Improvident reliance on credit leads to chain reactions of business failure, to competitive emulation, to manias and bubbles. Luxury, in short, loosens the key market-supporting character traits of self-restraint. The more general critique, restated in modern language, is that economic incentives may crowd out moral incentive. The exchange economy crowd out the reciprocal gift economy, and thus erode the felt obligation to voluntarily contribute one share. Some famous modern examples, the case studies of this are Richard Titmuss's study of how relying on commercial blood banks rather than on voluntary donations reduces giving and increases contaminated blood supplies. This wonderful study of how daycare centers in Israel, who started to fine parents for picking up their children late, found that parents who could be relieved of moral obligation by paying the fine were late more often. Competition, social and geographical mobility gradually replaced the solidary ties of community and authority. Towns, patriarchal households, religious and kinship trading groups, reciprocal duties of paternalism and subordination between master and servant, with perpetual conflict or relations subsisting only on calculated mutual advantage, thus destroying not only the communal infrastructures of moral and political order, but those of trust and cooperation, reciprocal obligation and authority on which commercial relationships depend. Just the other day I saw this argument used to explain why law firms collapse. They collapse when each of the partners is bent only on maximizing his own share of the take. They threaten to, or they do leave the firm, and the firm then falls apart. The families are the prime original incubators of the good bourgeois virtues, according to all of these accounts. But capitalists tend to be very hard on families. If you think that virtue rests on preserving patriarchal authority, the lure of commerce inverts that. If you think that it depends on the altruism and uncommodified labor of women, angels in the hearth, it subverts that. Culture critics like Phyllis Schlafly like to blame feminism for the lure of work that pulls women out of the home, but the main culprit is, of course, capitalism itself. The new power and freedom that women can begin to experience as wage earners, including the freedom to leave abusive or unhappy marriages and to seek out the welcome companionship of the workplace. Meanwhile, the shipment of formerly high-paying jobs overseas that supported the stable, or some would say the stagnant family life of the 1950s, leads to the shrinking domestic supply of employed marriage-eligible men. And the commercial ethic, for both good and bad, seeps into family life. The book I was just reading by Arlie Hochschild shows how families contract out for Filipino nannies who have to leave their own children on the other side of the world in order to take care of other people's children on this side. Or parents who pay professional builders at elementary school art projects, leaving children who still make their own art projects feel shamed and humiliated. For a phase of capitalist development, it seemed that commerce could indeed improve family life. by substituting technology for labor and gradually cutting work hours and leaving more time for leisure. But working hours, even in the advanced economies, have increased in recent decades, and both parents, if there are plenty to, are working more. Now, the big critique of commercialization is that the marginalizing mentality gradually devalues goods that you might quantify or monetize, like normative restraints on opportunism or strategic behavior that are embodied in law or commercial custom. The loyalty, trust, esprit de corps, sense of community, or associational identity that lead people, employers, creditors, trading partners, townsmen, to cooperate or support one another in hard times. The insulation of public officials, legislators, civil servants, judges, from the pressures of immediate economic or political influence, the desire to engage in public service, education, scientific research, or other forms of, to use an economistic metaphor of a kind that's become common, long-term investment in human or social overhead capital. The trickiest and probably most conscientious issues have to do with the effects of capitalist calculation on the moralities underlying market exchange itself. I've mentioned the arguments that markets can create their own underlying moral social orders because reciprocal dealings lead to norms that promote honesty in dealing. Relational contract partners, we know, pass up opportunities to take immediate advantage or refrain from strategic contract breaching for the sake of longer-term benefits in a particular relation. And for the sake of reputation in the wider market. But such normative orders always come under pressure from immediate short-term interests. It may be good business to pay employees high wages and benefits, treat them fairly, and give them expectations of tenure and promotion for good performance in order to induce loyalty and investment in firm-specific skills, reduce turnover, so that you can recruit and retain good people. But those interests will come for nothing if a significantly more profitable opportunity opens up, like a cheap labor source or sale to or takeover by another party with no such relational costs. Of course, such competition may sometimes result in aggregate benefits in the form of lower prices, but in the interim, they can license some pretty brutal and antisocial behavior. All too often, here there is no aggregate social benefit. Sometimes the only people who prosper are the villains of the last 2 centuries' tracts on morals. In 19th century tracts, the bad characters tend to be either the idler, or either the idler is either the rich, ostentatious consumer of luxury, or it's the vagrant, sturdy beggar, the speculator, and the predatory competitor. A good deal of intellectual energy in law and policy has gone to trying to draw lines between trading in beneficial markets and condemnable mere gambling, like insurance on the death of children, which was outlawed in the 19th century, or selling biodical policies, betting on the death dates of terminally ill insureds, or even buying and selling commodity futures, which was for a time illegal in the 19th century as well. If you contracted for the delivery of 20,000 pork bellies, that was an illegal contract unless you actually expected to receive those pork bellies delivered to your house on the day of promise. The legal system is at great pains to try to distinguish between fierce but fair tactics to drive out competitors on the one hand and malicious or spiteful destruction of competitors on the other, antitrust law, or distinguish between debtors down on their luck and in honest difficulties from absconding rogues hell-bent on cheating their creditors, bankruptcy law. The general category of the deplorable is sterile commerce, gratifying and enriching to some but not producing any social benefits, what we now call pure rent-seeking. In America, commerce was believed to be tightly allied, of course, with Protestant morality. Providence would reward honesty, thrift, and prudence with business success. And nowadays, preachers of the prosperity gospel still tell us that business success is a sign of God's favor. But good, cooperative, trustworthy characters can be simulated. In the footsteps of the honest trader, the mimicking every outward sign of his virtues walks the confidence man. I think Suzanne Blumenthal's next book is going to be on this subject. Karen Halterman, in her study of confidence men and painted women, has shown how by the late 19th century, every ambitious businessman was advised to become something of a confidence man. As she puts it, the manipulation of others through artifice was coming to be accepted as a necessary executive skill. She quotes from a success manual, "The first and fundamental principle of all dealings with men is that it is not enough for us to do, we must also seem." She's describing the birth of David Reisman's other directed personalities. As Arthur Leff, in a book of this title, pointed out, swindling and selling are fraternal twins. Now, the confident man poses a serious problem for the optimistic new commerce thesis, that market actors have a long-term interest in building up the implicit morals of the marketplace, relations of trust and reputations for fair dealing. The problem is that the good merchants actually open up opportunities for the fakers to flourish. The free-riding opportunist, the strategic defector and contract breacher, and the tax evader can take advantage of such trusted relations and reputations for their own short-term benefit. Credit card companies actually adopt a business model that relies on taking advantage of customers' cognitive limits. They say people should keep their contracts, while their business model actually depends on hiding the contracts so that most people won't read them. The investment banks and brokerage houses induce customers to think of them as fiduciaries, then sell them securities that the sellers are privately disparaging as dogs and selling short on the broker's own accounts. Banks and credit card companies pull in customers with teaser rates, then make their real money with hidden fees and undisclosed charges for changes in terms of service. Competitors begin to feel like chumps if they don't do otherwise. Over time, trust in everyone deteriorates. Consumers, workers, and investors can't distinguish between gold and brass. Costs of transaction are raised for everyone if all contracts must be made explicit, and if people have constantly to try to protect themselves against predation. So the links between personal virtue and commercial success are further weakened by the role of organizations, corporate and government, in attenuating responsibility. The ways in which organizations structure incentives in firm culture may lead to completely irresponsible behavior, which in turn leads to huge losses or the death of the firm. Managers struggle for dominance and status in the organization, sometimes disconnected from any value-producing goal. Every actor wants to pocket for himself as much as he can, to put other people's money at risk, and if possible, dump his own losses onto others. So instead of the prudent, rationally calculating merchant, we may get the organization man, who orients himself not by some inner compass, by what he senses are the expectations of the people, or who in the restless competition for status and position, they become his patrons and superiors. For the middle manager, the organization looks like a maze, a combination of the Duc de Saint-Simon's palace of court intrigues and Kafka's riddle state. Loyalty and conformity are what get you ahead, not prudent assessment of risk or beneficial relations in exchange with customers, investors, suppliers, and workers. This is the nightmare picture of the corporation, painted by a number of notable sociological studies. Obviously not true of all corporations, just as obviously true of some. Reputation fails as a guarantor of future untrustworthy conduct because the people in the organization who betray the trust of consumers or investors or contract partners know that when the music stops, when the toxic waste dump is discovered, or the key product malfunctions, or the earnings are found to be fictitious, they can find someone else to take the blame, or they will simply move on to another firm. Nonetheless, the view that the market is the theater of virtue, that market winners are the most deserving of success and that losers deserve to lose, is surprisingly resilient. Especially in periods where entrepreneurs and large firms seem to bring about a general prosperity, we want to believe in it. Just as we want to believe in a just world, where the good guys prosper and the wicked are shamed and punished, as at the end of every Dickens novel. But that view is pretty hard to sustain, especially after a recession caused by the collapse of the speculative bubble. Everybody knows perfectly hardworking, talented, decent, and honest characters who lose their jobs and pensions or houses through no fault of their own. While many of the ruthless, cunning, or simply privileged not only continue to flourish, paying themselves large bonuses out of government bailouts, but to be arrogantly agreed that anyone should blame them, and even insisting that it was all the fault of the losers for believing their hype in the first place. The Gilded Age had a name for undeserved riches, freaks of fortune. It's true that unlike the idle rich or well-born of past eras, many of today's market winners can truthfully claim that they work hard. And of course, so many of the people we call losers or moochers or takers, often 2 or 3 jobs in the hospitals or restaurants or fields. Now I come to the surprising part. That law and lawyers can be the cure, or part of the cure for this lamentable, melancholy knowledge they can't help. They can't completely counter these things. Now, so far as I know, in no other country than the U.S. have law and lawyers been advanced as comprehensive solutions to the problem of maintaining, in a commercial society, the social bonds and supporting orders which are necessary to the survival of capitalism and relatively exempt from commercialization. How did this happen in the U.S.? As of 1800, the ministry had lost much of its leadership authority, and the imperial bureaucracy of England had been disbanded with independence. Lawyers remained as the one non-strictly business occupational group with significant public influence. Though the profession's practices were often sharply criticized, the public prestige of the lawyer, architects of independence and the constitutions was enormous. Here, if anywhere, were the patriot statesmen of the ancient republics. In a society absorbed in business, making money, and getting ahead, lawyers were uniquely well positioned to claim political, social, and even cultural leadership. Elite lawyers dominated the country's cultural intelligentsia, such as it was, edited all major political and literary journals, produced the most impressive cultural products at the time, the legal documents and theoretical tracts of America's political constitution. Lawyers were key members of local community elites and also of the political and commercial networks that linked communities together, the seaboard and the hinterland. Law was the preferred route to public office, and it fell to this extremely articulate group of lawyers to articulate the form of the critique of commercial society that emphasized law and lawyers as the cure. Let me briefly summarize their arguments, many of which a distinguished French visitor incorporated into his famous Democracy in America. First, lawyers have the training and virtue required to maintain the institutions of legislation. They're a natural aristocracy. Their primary professional commitment is the principles of legal science, which properly understood are the mainstays of the rights of property and the principles of justice. The long-term logic of the common law was to unfold towards an increasingly purer science of liberty and utility. Law training is also training in the science, what Smith called the science of the legislator, a science learned by immersion in the study of political economy and the comparative history of republics. Lawyers have pre-commercial ambition. They're capable of civic leadership, commercially motivated public service. Hence, they can serve as this natural aristocracy of merit, functionally substituting for the aristocratically recruited directing classes or elite bureaucracies of Europe. The solution to the dilemma of authority in a democratic and commercial society is professionalism. The authority of lawyers is not subject to question as that of birth in a republic, nor as unstable as that of wealth, because it's founded on professional merit and privileged access to knowledge of the legal, political, and moral sciences. Similarly, lawyers are in a position both to practice the civic virtues and to help instill them in the citizenry through instruction. They know the principles of Republican institutions, especially since these have now been embodied in legal documents, the constitutions, capable of professional interpretation like any other legal texts. They have a training in oratory, the medium of civic instruction. They're generalists, brought into contact with a wide variety of trades and perspectives through their work. They have access to public pulpits because of this training in their ordinary occupations, write judicial opinions, give charges to grand juries, speeches on the floor of legislative assemblies, circulate letters to constituents, argue before petty juries and appellate judges. In a society where people pursue diverse projects, law can be an integrating force. people will be unified in their devotion to the Constitution and the laws. Lawyers form a separate autonomous group in civil society and a state independent both of the democratic state and of commercial wealth, capable therefore of mediating between the people and the property and of restraining the destructive excesses of both. As Hamilton in Federalist 35 writes, "Will not the man of the learned professions," and he clearly means law here, "who will feel a neutrality in the rivalships between the different branches of industry, be likely to prove an impartial arbiter between them, ready to promote either, so far as it shall appear to him conducive to the general interests of the society? Lawyers are even in a position to promote the private virtues by promoting good laws and by interposing discretion in the application laws, and third, by setting a personal example of virtuous conduct. Lawyers have some specialized knowledge of systems of morals, the principles of natural justice. Good laws mostly conform to such principles and help conserve as proper virtues. The obvious example is promise keeping. We ought to keep our promises, and law mostly makes us do so. Law even confers many obligations of benevolence, such as the duty to support children, which are legal duties. And one of the main doctrinal devices for integrating law and morals in the early 19th century is that of the implied contractual promise to do as morality and sound policy dictate. The contract is not yet esteemed as embodying only the private or selfish intentions of the parties, but as enforcing what they ought to desire. In a pluralistic society, law can substitute for traditional sources of morals, can help inculcate moral norms. Men are not angels and require restraints on their baser impulses, and religion helps to keep them moral through the example of Christ and the fear of hellfire. But law is what helps keep them moral in this world. And law isn't just a collection of prohibitions, it's a guide to conduct. In the diverse and pluralist world of nations, regions, and factions, a set of rules of the road. Lawyers, by virtue of their knowledge of the rules and the law of nations and the constitutions, have a privileged and elevated status as transmitters of public value to the citizen. Lincoln famously went so far as to call law and the Constitution America's civic religion. Let, to quote him, "reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught," to think of teaching your 4-year-old who against perpetuities. Let it be taught in schools, in seminaries, in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in calls of justice. And in short, let it become the political religion of the nation. And let the old and the young, the rich and the poor, the grave and the gay, of all sexes and tongues, colors and conditions, sacrifice unceasingly on its altars. Now, for many reasons, this very elevated view of the lawyer statesman fell out of fashion by the late 19th century, but it didn't disappear. It was replaced by a more modest theory of professions and professionalism. This is the professional idea of organization and practices and service exemplify a social ideal and a model of social practice that is vital in modern society to counteract or redeem the sort of centrifugal, disintegrating, or self-undermining mythologies of modern societies generally, and capitalist societies in particular. And most hopeful versions, like those of Durkheim and Veblen and R.H. Tawney, the professions point the way to a higher and more advanced stage of social development, in which the profit motive and property rights will, in every occupation, be subordinated to more public and social regarding concerns. The ethics of professional associations, collegial solidarity among professions, their ethics of care and craft, vis-a-vis clients and customers will extend to business and its cadre of professional managers as well. In the socialist and social democratic variant of this vision, professionals will repay their original debt to the working class, their appropriation of craft artisans, valorization of hard work, guild organization, and peer solidarity and high quality product by extending professionalism downwards to workers inside the factory or firm, making work relations more collegial and cooperative, and work more meaningful and imbued with craft and service ideals. And within this tradition of broad theorizing about the professions, the resulting developed a more limited and down-to-earth version of the broader case for the positive functions of professions in model society. The society has to associate this view with Tocqueville and Colton Parsons. It is that professions have a special role within the advanced capitalist tradition of occupational labor. Societies have some functions that must be performed by occupations, not subject to ordinary market relations and the calculus of profit. There must be islands of work in which are relatively insulated from market pressures of judgments and outcomes that cannot be bought and sold, and are relatively insulated from politics and the clash of self-interested groups and factions. Jobs whose occupants are not primarily interested in making money or pursuing a factional agenda who are disinterested. Obvious examples in medicine and public health. People who take the patient's health or a population's health as their primary concern. Scientific and medical research, people who can be counted on to enforce themselves and others' integrity and methods and importance. In law, people who, even in their role as adversary advocates, take care to preserve the integrity of the substantive and procedural frameworks that structure their roles. And in judging, administrative, and enforcement, people who will apply the law impartially without bias or corruption. Civil service administration, people who take seriously the idea of the public interest, even if they have political disagreements about what it is, and agree that public careers are not simply realms for self-seeking. The institutional guarantee generally being salary and bureaucracy with some particular profit. Now, this functional view can easily expand back into a version of the ambitious claims for professions that they serve as the glue of society, that they can help constitute or mediate among the various specialized activities of society. You see this most ambitiously in Hegel's claim that the bureaucracy is or ought to be a universal class. And in the ideology of the profession of civil service, especially as developed in Germany, that it should consist of disinterested professionals committed to a scientific view of social problems and to the service of abstract general law standing outside politics and even outside the state. In the USA, this ideology clearly reached its height in the progressive period, in which it was assumed, at least by professionals, that professional modes of cognition, organization, and problem solving would be able to extend widely into domains of social life, hitherto occupied by markets and politics. Now, as we know, professions and professionalism came under severe attack in the 60s and 70s. Skeptical economists and professions, they said, were state-protected cartels whose main purpose was to raise barriers to entry, to restrict competition, and ultimately to extract monopoly rents by combining fixed prices and the terms of service compliance. And skeptical sociologists saw the purpose of professions not only as attempts to control markets, but to preserve for themselves a status niche in the class structure, and to establish a spurious cultural authority by mystifying their expertise. Bernard Shaw's words, professions were nothing more than conspiracies against the laity, whose dominant functions were to serve their own interests by controlling markets for their services. In that era, all authority was called into question, and professional authority was not spared. But the need for independent judgment that cannot be law or corrupted has not gone away. Corporations still need what we call reputational intermediaries, people who can be trusted to certify to investors and customers and regulators that their financial reports and earnings statements, tax returns, labor, anti-discrimination, and environmental policies were as the companies claimed them to be. People whose social capital was supposedly they could be trusted not to lie for the sake of a fee. People like accountants, credit reporting agencies, and of course lawyers. The professional as gatekeeper, which was the new term for this function, might not be as heroic as the professional as Ciceronian patriot statesman, but she is necessary nonetheless. And at the same time, this professional idea was reinforced by the rule of law movement, in which companies doing business abroad and international investors and lenders came to believe that the crucial institutional element in the developing country was commitment to the rule of law. And the World Bank and USAID and the ABA poured millions into rule of law projects in ex-communist and developing countries. The key institutions promoted were courts staffed with independent judges. The focus on building judicial capacity, strengthening courts, improving the quality and training of judges, and establishing constitutional arrangements that define the scope of restraint over the exercise of governmental powers and prevent individual rights. Markets, it turned out, needed the non-market institutions of law and lawyers, or at the very least, of judges. Well, okay, so, but, alas, the laws actually practiced seemed often as much undermined as to protect the frameworks of justice and legislation. Law is, of course, complex, technical, and manipulable. Asserting a legal right, therefore, means sometimes just buying a lawsuit whose outcome is uncertain. Lawyers have a guild stake in technical mystery and a financial stake in complexity, so they don't aggressively promote certainty through simplification. And anyway, of course, lawyers, people sometimes forgot this in talking about the objective role of lawyers in commercial society. Lawyers are first and foremost advocates for clients. They may on occasion act as exceptional servants of the Republic, but by vocation, they're partisans for private interests. And adversary advocacy, by treating the content of law as contestable and openly conflicting interpretations, undermines its conventional stability. Lawyers may respond that they argue both sides, and a judge or jury decides, but of course most lawyers advise communicating law to clients and helping clients structure transactions to conform to law will never be reviewed by a judge or any other authoritative interpreter. The practicing lawyer's perfectly sincere working idea is that conformity with any plausibly arguable construction of legal texts and precedents as applied to what the clients want to do, even those that thoroughly frustrate the law's purpose, is perfectly legal. And indeed, the state would violate the rule of law if it failed to accept it. Creative compliance can thus become a tactic of using rule formality against itself, so as to nullify the force of rules. In many kinds of practice, perhaps especially these days, regulatory tax practice, the professional norms tilt the system towards anarchy, or whatever helps the clients. At its worst, this practice sabotages the state's capacity to tax and regulate well-lawyered parties. In societies where state administrative capacity is weak to begin with, as in the developing world, it makes governance impossible. It now appears that the use of legalism to work around regulatory safeguards that are supposed to protect companies and their stockholders, investors, and the public from fraud and excessive risk-taking is one of the causes of the current near collapse of the world economy. And law is very expensive. If the rule of law idea is law consistently and predictably and fairly and equally applied, it's hardly obvious that the introduction of lawyers and their skills will serve that ideal. The biggest problem, the basis of charges leveled against lawyers since antiquity is, of course, that lawyers profit from delay and complexity, which makes vindicating rights uncertain, costly, and slow, and almost invariably favors richer parties, and that legal talent tends to serve those who can pay their fees and protect its privilege, which also generally favors the rich and powerful. The openness of courts and litigation remedies to different classes of litigants is exceedingly variable across time and society. American courts actually be more accessible by some margins than most. But everywhere, many of law's procedures are restricted to practical as few can afford them. And in our own history, Lincoln's hope the culture of legalism could serve as the moral glue of society, or at least as a means of forming and integrating a national culture based on respect for laws and delivering severe impact by the slave owners. And indeed, from the founding of the Republic onward, lawyer Bishop Jeremiah is complaining that lawyers are squandering the most valuable cultural asset of their profession, its potential for exemplary political and moral authority, by sacrificing its pre-commercial ideas of character and merit, liberal learning, public service, collegiality, success defined as extended to the ordinary commercial ones of profit maximization. These laments are common by mid-century, and by 1900 they become a chorus. The main problem as contemporaries saw it was that the leaders of the bar had abandoned their commitment to functioning as an independent bar, mediating between the excesses of autocracy and democracy, of private innovation and government obedience, and simply become vassals of the business combination trusts. Some of these same lawyers then spearheaded reform movements to redeem their independence and bring their own clients under control. In the 1980s, we heard many of the same complaints all over again. Law had become a business. Profits were partner based primarily on the ability to recruit clients rather than professional ability and become achieve long-term success. Now, in recent decades, the claims that lawyers are or should be the exemplars and transmitters of public values, guardians of the public purposes of the law, a system of restraints on liberty, and mediators between excesses of democracy and autocracy have actually almost completely disappeared from the better self-image of most of the bar. The exception is perhaps some lingering libertarianism in the idea of the bar as a defender of economic liberty against tyrannical and overreaching state regulation and taxation. But one hears rather less, except from the plaintiff's bar, of the first and most basic idea of justice as protection of rights against private as well as government predation. The business lawyers on the whole see themselves largely as part of the financial and business services industry, selling complex technical skills to help clients minimize legal costs and manage risks of the global economy. What about the more modest gatekeeper role? That of lawyers as well as accountants as reputational intermediaries. The lawyer's opinion is supposed to make securities or tax shelters more marketable by certifying their compliance with law. Obviously, that can only work if the opinion is reasonably objective. Investors or regulators have to believe that professional ethics and concern for reputation would prevent the gatekeeper from representing things to be true if she didn't think they were. But if she has her job to be simply to promote the appearance of compliance with law, to put a gloss of propriety or sprinkle holy water on dubious transactions, then of course over time the advice becomes worthless. Because the people who are supposed to create market confidence become the means of undermining it. If you know you can't trust anything a lawyer says because the lawyer defines his role as hyping the facts for the client, in situations like the great Enron scandal of a couple of decades back, what the lawyers did was to produce no opinions. Opinion that, if read with great care, actually said almost nothing about the legal validity of the transactions, but nonetheless supplied a kind of gloss or appearance of reassurance. Many of the gatekeepers, it turned out, were only confidence men. And the case Tocqueville had made for lawyers was that they would be conservative guardians of traditional order against the disruptive tendencies of commerce and democracy. He lists them in his chapters on the tendencies which contain the excesses of democracy. But capitalism is an inherently disruptive force, especially of traditional hierarchies and communities. And the modern corporate lawyer is a promoter of her clients, not a defender of tradition. She wants to be forward-leaning and strategic, and eager to implement her clients' business plans, not an obstructive stick in the middle. Now, this entrepreneurial temperament is in some ways one of the great assets of the American legal profession. As compared to others, our lawyers actually try to solve problems, not tell the client that they can't solve. But it's a series of unfolding scandals like the fall of Enron have demonstrated and the recent financial. It also inspires some lawyers to cheerfully help rogue agents loot the company for their own benefit, drive it into bankruptcy to the ruination of shareholders, creditors, and workers, and then tell the world they would do it all over again. The many rule of law projects in the developing world have been mostly disappointing, more disappointing than catastrophic. Most reforms haven't taken or have had only modest results. A World Bank report from a few years ago concluded most of these interventions produced little change as experience grew. It became clear that the roots of poor performance in the judicial system lay much less in the lack of resources or skills than in the behavior of judges, clerks, lawyers, and litigants. Well, that's just about everybody. The very people relied upon to execute the project seem to have gone the way. In the wake of such failures, the argument gains ground that law, instead of supplying surrogates for the commerce-dissolving manners and morals of pre-capitalist society, actually hastens their further dissolution. It's now often law that's alleged to promote dissension, adversary conflict, litigious contempt for authority, and the displacement of trust relations, allowing for flexible and equitable discretion for insistence on rigid and technical rules. So what about the personal character of the lawyer as moral exemplar? I'm not fully confident that anybody except lawyers themselves ever completely believe with this. In general principle, in public opinion, people have had a pretty high opinion of judges, but a rather low one of lawyers. The image of the lawyer as the steadfast upholder of traditional rights against special factional interests, or as mediator between democracy and plutocracy, or as personally exceptionally truthful and upright, has never gained much traction in popular opinion. Though, in fact, I think such admirable lawyers are not nearly as rare as the cynical public might think. Lawyers must sometimes try to lend weight and credibility to causes and clients whose own mothers would disown them. And occupational hazard is becoming morally weightless. The detached, never committed to any person or cause, never responsible for any consequence. Like Camus' Jean-Baptiste Clémence in The Fall, or Tolstoy's Ivan Ilyich, going through the forms and rituals of a respectable occupation. Or take the lawyer narratives of Lawrence Joseph's, the chilling, the familiar and plausible monologues in Lawyerland, garrulous, witty cynics, contemptuous of everything but their own cleverness, making a joke of their own self-loathing. Now, almost everybody here, I imagine, knows some morally exemplary lawyers. But it is not always easy to argue that it's the habitual practice of their profession that makes them so. Well, what can we, okay, so what can we learn from these debates? I didn't have time to fill in the rest of that. First, we have to acknowledge, even though many smart people are still unwilling to do so, that the optimistic du commerce theory that the self-interested behavior of market actors will be adequate to mitigate the problems caused by market activity is just not credible. The inadequately regulated markets recently very nearly brought about a collapse of the global financial system, and they're likely, if unchecked, to destroy the planet itself. Even though economic growth improves the living standards and working conditions of billions, as it undeniably does, the conditions of perpetual insecurity generated by global markets often wreak havoc on family life, community stability, and political order. And rising income and wealth inequalities make a mockery not just of democracy, but of the basic preconditions of equal justice and free legislation, by giving the few preferential access to government privileges, subsidies, exemptions, and immunities. Reliable evidence, for example, indicates that in our Congress gives the preference of the top third of the income distribution 50% more weight than the middle third, and the bottom third it gives no weight to at all. Even judges, especially in the states where most judges are elected, are being purchased and sold as commodities in a competition between the plaintiffs' bar and the Chamber of Commerce to see who can buy more favorable decisions. Now, this ascendance, I think, of economistic ways of thinking has threatened to deprive us of the very vocabulary that we use to talk about the purposes and the personnel of the public domain. Public choice theory indeed suggests the public sphere is reducible to interest-group rent-seeking is nothing more than legalized theft, which in its rawest versions would seem to suggest that no differences can be found between more and less corruptible governments, which I think is quite absurd. Even the public choice theorists think, however, that there must be some kinds of laws, common law or constitutional law, which are not, or at least are less subject to capture and corruption. The history of these dialogic moves and the circumstances that inspired them is actually not one of a steady slide into decadence and disillusion, unrelieved cynicism and abandoned hope. On the contrary, it's possible to see this entire history as one of constant refreshment and renewal, a repeated search for fresh experiments and fresh solutions. Regularly, as evidence piles up of the corruption and capture of the public sphere and of the professions that are supposed to embody and uphold public values, so too does the demand for reform of the cultures and institutions that form the indispensable infrastructure of markets. The basic justification is what it always was, that professionalism solves problems that markets not only cannot solve, but often exacerbate. The problem of supplying the social need for disinterested judgment that is not for sale to the highest bidder, for a primary ethical orientation towards service of people in great need, a need that can easily be exploited by the unscrupulous, and an orientation towards criteria of quality, as well as cost effectiveness and profit, and towards the production of public and merit goods like scientific methods, scientific research, and a livable planet. Market forces cannot reliably produce those goods, and regulation cannot reliably compel or guarantee their production. We still need people with the appropriate internal orientation to an ethic of service, care, quality, and long-range consequences, and we are not going to attract or produce such people through profit incentives or micromanagement. So So something like the Republican or professional idea is starting to look very appealing again, just as the conditions for its effective institutionalization seem to be eroding. The agenda should not be to scrap it, but to search for ways to nurture it under the new conditions. Now, of course, you can't produce such institutions and ideals by wishing them into being, or even by convincing demonstrations of their functional necessity. They're almost invariably products of crises followed by political reform movements, like the revolt against old corruption in 19th century England, which produces civil service reform, or the regressive revolts against corrupt alliances between businesses and machine politics of the 20th, often spearheaded by professionals looking for self-respect and meaning in their lives, like the hundreds of lawyers who deserted corporate practice and staffed in New Deal, the public interest lawyers in the 1960s and after, who brought us the effective realization of the Bill of Rights as a charter of liberty and equality, and by human rights lawyers in the present day. And I take comfort from the fact that young men and women animated by these ideals are still coming into our law and public health and public policy schools. There are many of them among my students, and more than anything else, these young people are what give me hope for the future. All things fall and are built again. In the 19th century, reform movements replaced the corrupt fee-for-service government with salaried and tenured civil servants. In the 20th, progressive movements reformed corrupted and politicized judiciaries, remade the federal constitution by remaking it into a charter of equal rights, and began to socialize risks of old age, disability, sickness, unemployment, and business failure in ways that markets could not. Lawyers were hardly alone in staffing such movements and reforms, but they were a big and very important part of them, and they will be again. Thank you.
We have time for probably about one or two questions.
So sorry to go on so long. This is long.
Oh, sorry.
I have two thoughts. One, I think what this process is like, if you talk about gender roles, it seems like maybe it's just in this story as they just criticize them for being at home and treat their toddlers and little duties.
Well, in the original story, of course, women had an indispensable role. I mean, as the producers of moral order, I mean, they were part of the supporting infrastructure. You know, women like law and religion were essentially it's the uncommodified labor and love of women which makes market capitalism tick. And they thought, well, you needed all of that the big argument against bringing women into politics and market relations, this would corrupt them and make them incapable of performing this harmonious producing role.
That's fine. It's fine. Is there an argument that once women are in business, they're more virtuous and they're less virtuous? You know, what happens once women?
Well, as you know, there's actually a sociological literature on this, some of which goes kind of both ways, right? I mean, some of which suggests that women are actually somewhat more virtuous in business settings, that they're better at relations, that they're less impetuous in decision making, more farsighted, more exemplifying of the old-fashioned bourgeois virtues of restraints on selfishness, better team players, more empathetic managers, and so forth. There's also a counter literature that says, well, yeah, but once you have women in business and professions and in large numbers, a lot of these differences appear. But I think you have probably come across many versions of the argument that increasing numbers of women in business and politics are going to improve the performance of the spheres, and all because women are just more used to sacrificing immediate self-interest for the care and concern of others, and people hope that there will be some carrying over of these traits into the market sphere and into the public sphere of business. Actually, my own observations are that this is to some extent true, but I don't know. What do you think?
I'm less interested in the actual reality of
Yeah.
other people.
Right.
But the second question is, what's the role of law schools?
Well, law schools, I mean, this, I just wrote a long and impassioned screed on this very subject. I think law schools have potentially a very important role in this. I'm actually very much distressed by the new vocationalism, which seems to suggest that the sole legitimate role of law schools is to teach and improve people's practice skills, because we're not just teachers of lawyering, we are teachers of law. And what law is the public framework of institutions and restraints and procedures that make the whole system work. A certain amount of practice skill consists in work that effectively undermines the stability and enforcement of the laws. We have an official ideology that this is counteracted by adversaries and the adversary system, but of course most legal advice is not. Most legal practice is not within the confines of the adversary system. And we have inappropriately lifted a view of the relation of lawyer and client from the context of trial practice and adversary advocacy into the counseling function, where none of the safeguards for adversary behavior exist. Everybody seems to think that an awful lot of people seem to think that law is just about serving the needs and the interests of the client, and forgetting that law and lawyers are the principal means by which knowledge of and compliance with law are transmitted to the citizenry at large. You tell some lawyers this, they say, well, we don't want to be cops. And you say, well, look, you have to be, to some extent, enforcers of the law. It's the laws that give you your standing and your occupation and your role. 19th century political theorist Francis Lieber, I think, put it very nicely, in which he said, it is inconceivable that a society first with great pains and efforts makes laws, and then licenses the whole skillful professional craft to undermine them. We're in the training lawyers business, but we're also in the rule of law business. One of the things that we need to do, I think, is to try to inculcate knowledge of and respect for the frameworks of law in which market activity takes place. So this is a direct relevance to what I'm talking about that today. And you don't get that by teaching people how to be more skillfully strategic lawyers. You can improve law practice by making people more honest, more competent, more skillful, more talented. I'm all for that. That's one of the functions of law school for sure, insofar as we're good at it. We're good at some parts of it, not so good at other parts of it. I don't think there's much point in asking law school to do things that apprenticeship could teach much better and more efficiently. But certainly we should teach lawyering skills. But I think more important than lawyering skills, and this was not a controversial proposition until maybe the last 15 or 20 years. In addition to lawyering skills, we need to teach people how to uphold and maintain and keep in repair the framework of laws. If lawyers don't do it, it's a safe bet that nobody else will. This is, serving clients is our business. Maintaining the framework of laws is also our business. And law schools, I think, have a lot more to say on the second than on the first.
We have food and drink upstairs in the RRAC Commons. We invite you all to join us up there. But first, we'll